by the Supreme Court of Guam. I just would like to say a few words and acknowledge this historic day for the Guam Supreme Court. First of all, I would like to thank the lawyers who've agreed to participate in the first virtual Supreme Court oral arguments. Attorney Peter Perez and Attorney Genevieve Rapadas. And the rollout of our first virtual Supreme Court oral arguments couldn't have happened at a more appropriate date. Of course, we would have preferred to be in our courtroom where we've conducted all of our oral arguments, except when we have gone out into the community and in celebration of Law Day, like what we are doing today. And today is May 1st, and every year on May 1st, for the past at least 10 years, we have celebrated the role of law in our society. And we have sought to cultivate a deeper understanding of the legal profession. And today we are doing that today by having our first virtual Supreme Court oral arguments. And a first for us is we are also live streaming this so the public can watch the court in reference as to the process and how we arrive at our decision making. It's been a lengthy process for counsels in bringing the case to this point, and we are in the final stages of finally resolving the case that has been appealed to our court. Before we begin, I would like to say a little about the Law Day 2020 theme. And at first, I'd like to acknowledge and thank Justice Torres, who has been the perennial chair of our Law Day committee and has been very successful in the events that have surrounded our Law Day. Unfortunately, we have to modify ways in which we have brought our Law Day activities to the community. And one of the ways is what we are doing today with our virtual Supreme Court hearing. The Law Day 2020 theme is Your Vote, Your Voice, Our Democracy, the 19th Amendment at 100. In 2019-2020, the United States is commemorating the centennial of that transformative constitutional amendment that guaranteed the rights of citizens to vote would not be denied or abridged by the United States or any state on account of sex. American women, in the history of our Guam society, have fought for and won the vote through their voice and action. And the women's suffrage movement forever changed America, expanding representative democracy and inspiring other popular movements for constitutional change and reform. It is an honest reflection on the suffrage movement that reveals the complexity and tensions over race and class that remain part of the ongoing story of the 19th Amendment and its legacies. The Law Day Committee, under the chairmanship of Justice Torres, had really specific plans in terms of elaborating on this theme. And we hope that, although slightly modified, we can continue to bring those plans to the community of Guam. And so before we begin, Justice Torres, as chair of the Law Day Committee, would you like to say a few words?
Just some brief remarks. Thank you, Chief Justice. First of all, I do want to thank the Law Week Committee for their tireless effort in terms of organizing these programs every year. We've been recognized by the American Bar Association on countless times for having the best public law day program in the nation. And we would not have been as successful without the contributions and efforts of our entire committee. I do want to just emphasize to the people who might be watching us that we're still going to be trying to do a number of events, notwithstanding the surreal circumstances that we find us in currently. The art and essay contests are still ongoing, and information can be found on the Judiciary of Guam Facebook page. as well as in some public announcements that have been in the past and will continue in the future. Or there is an iCivics program that's being produced by the Guam Bar Association, the District Court of Guam, and the Judiciary of Guam. And so I encourage everyone to still get involved. We're going to also be doing a virtual mock trial with some of the students from various elementary schools, and provide an opportunity for the people of Guam to see their hard work that they've put in this year in their program. We just didn't want to see it end despite the challenges that we face. There is one other thing, and I'd like to just ask us to briefly take a short moment of silence to remember this year's Justicia Award winner, the Honorable late Chief Justice Peter Seguenza, who was named the winner of the Justicia Award. It's always awarded as part of the Law Week festivities. So if we can just take a brief moment of silence in recognition of Chief Justice Seguenza.
Thank you, Justice Torres. And before we begin, I will just like to point out that the justices are actually practicing social distancing and conformance with the declaration of emergency that the governor has declared. However, we continue to we continue to push the wills of justice forward. And although we may have to modify how we do things today and going forward, the judiciary of Guam is determined to continue with the work that it's been tasked with in terms of the community. And so Justice Merriman is at her residence in Sanahaña, Justice Torres in Santa Rita, myself in Pidi. Genevieve Rapadas is going to be arguing from her office in Hagatna, and Attorney Peter Paris is at his home in Barragata Heights. So with that, I'm going to ask the clerk to please call the case.
This is Supreme Court case number CVA 19-002 in the name of Rosanna E.D. Palmer, Plaintiff Appellee versus Marianas Stones Corporation, Defendant Appellant. Plaintiff Appellee Rosanna E.D. Palmer is represented by Attorney Peter C. Paris, and Defendant Appellant Marianas Stones Corporation is represented by Attorney Genevieve P. Rapadas. Your Honors, Attorney Peter Paris reserves 10 minutes for rebuttal.
So, Mr. Paris, before I ask you to begin, as we had informed counsels before today's hearing, a slightly modified manner in which we're proceeding is that each counsel will have up to 5 minutes at the beginning of your respective arguments, uninterrupted minutes, to present his or her arguments before justices are going to be allowed to ask questions. And then we are going to carry on just as how we would carry on if we were in the courtroom. So at this time, Mr. Paris, you are recognized.
Thank you, Your Honor. Good morning, Chief Justice Carbolito. May it please the court. By this appeal, Marianas Stones seeks from this court vacation of the lower court judgment. We request entry of judgment in Marianas Stones' favor. Alternatively, we request that the judgment issued by the trial court be reversed and that the case be remanded for new trial or for such other relief this court may grant. Additionally, we ask for an award of attorney's fees. We submit that the lower court, by its judgment, deprived Marianas Stones of its day in court, of its ability to present its defenses or to have its defenses considered, and that the rulings by the lower court were based upon form over substance, hyper-technicality over merits, and a deprivation of fairness and substantial justice to Marianas Stones. We've submitted a rather extensive brief regarding our position on this appeal. And what I'd like to do is highlight some salient points from each of the issues that we've raised. With respect to the first issue, mitigation of damages, the trial court denied Mariana Stones of the ability to argue plaintiff's failure to mitigate damages. It is our position that this was error because under law, a commercial landlord has a duty to mitigate damages. This is triggered upon a tenant's abandonment or breach of a lease. And the burden at trial is on a lessor to show diligence. This is a matter of public policy. And when we look to the civil jury instructions, we see that mitigation of damages is not identified as an affirmative defense when we look through the civil jury instructions 330 through 337. In fact, there is a specific instruction under number 358, which provides for a plaintiff's requirement to establish that they've mitigated damages. Under the law, if Ms. Palmer did not mitigate damages, she would not be entitled to recover for the avoidable harms. The second issue we've raised is force majeure. And what I'd like to say regarding force majeure is really, I don't think this even necessarily needed to be pled or raised as an affirmative defense because force majeure really is an essential term of the party's underlying contract, the extraction lease. Under the complaint, which is a one-count complaint, plaintiff alleged breach of contract. They invoked the extraction lease in their complaint. They attached it and incorporated it in their complaint, and they cited to the terms of that contract. In Mariana Stone's answer, they denied liability. They denied any allegations which they did not admit, and they pled affirmative defenses, including affirmative defense 4, that there were superseding causes outside and beyond Mariana Stone's control. What else would this affirmative defense be other than the issues raised in this appeal? When we look at the extraction lease, under paragraph 15, it talks about how the lease is to be construed according to the plain meaning of the language. Under paragraph 17, it talks about descriptive headings not being controlling. And under paragraph 9, which is titled force majeure, under the reading of the lease as a whole, that title is not controlling. And it provides when compliance is prevented or delayed by, for example, a regulation or an inability to obtain permits, which is what happened in this case, or a cause not within the control of a party, there's no liability. This is an essential term of the contract. So when I say Mariana Stones did not necessarily need to plead this as an affirmative defense, that this was an issue that Mariana Stones should have been able to present in arguing the issues of the contract that were at issue in this trial, Mariana Stones was deprived in doing so by the court's ruling depriving Mariana Stones of being able to raise that paragraph of the contract. I would note also that to the extent that this is required to be pled as an affirmative defense, under the Guam Rules of Civil Procedure 8C, it doesn't say force majeure specifically. We're not required to say the words force and majeure in order to raise this as a defense. All we need to do is plead a matter of avoidance of defense. And under Rule 8F, the pleadings are to be construed to do substantial justice. The issue, now in this case, backing up, the purpose of pleadings is to give fair notice to the adverse party. And in this case, the adverse party, Ms. Palmer, surely and truly knew what Mariana Stone's position was. And this is based upon the pre-litigation facts, the terms of the extraction lease, the answer to the complaint, and specifically under defendant's discovery responses. Now, what was argued during the trial court level, Ms. Palmer argued that she would be prejudiced by permitting Mariana Stones to be able to raise paragraph 9 at trial. But this is not so, and this alleged prejudice was not based upon fact. For example, if we look at the interrogatory responses from Mariana Stones, excerpt of the record 121. Mariana Stones told Ms. Palmer that it was going to be, that its defenses were based upon the Fish and Wildlife Service's denial of permits. It was based upon the 20 citations that were issued against it. It was based upon the threatened seizures of its property. It was based upon the numerous court appearances Mariana Stones was required to make. It was based upon the threat of criminal liability that Mariana Stones was facing. And it was based upon Ms. Palmer's sister's motion to clarify, under which she clarified a consent decree where she asked for permission for Mariana Stones to be able to haul aggregate under the contract. We also looked to the supplemental responses, and in excerpt of the record 122, all of these facts are given to support affirmative defense.
Mr. Paris, before you proceed further, in reference to your argument that the court prevented MSC from arguing the force majeure and the failure to mitigate, the trial court denied MSC the opportunity to present evidence based on waiver, and this was done early in the process through a motion in limine. And the trial court was concerned that MSC waited over 27 months after its answer to raise this force majeure and failure to mitigate defenses. And I think it was only 10 days before the trial was to begin in terms of a trial brief where it then sought to add 4 new counterclaims and 15 new affirmative defenses on the eve of trial. And so I think that was part of the context in which the trial court denied MSC's requests to present on this force majeure and failure to mitigate. And so of course, as you pointed out, in reference to the potential prejudice to Mr. Palmer, and also in terms of what was allowed to eventually proceed. So why wasn't the trial court really correct in denying and then granting the motion in limine, since MSC waited over 27 months before it even raised these 2 defenses?
Well, number one, Your Honor, one of our positions is mitigation of damages, and paragraph 9, whether it's titled force majeure or just a term of the contract. Those are issues, number one, that we submit did not need to be pled as defenses. Those are, mitigation of damages is a requirement by law, not required to be presented as an affirmative defense. Paragraph 9 which is titled force majeure, but that title is not controlling, is an essential term of the contract, and it is specifically addresses the facts underlying this case. Mariana Stones entered into this extraction lease specifically to extract aggregate, and it was unable to do so because of a regulation asserted by Fish and Wildlife and its inability to get permits by Fish and Wildlife. This was the underlying dispute. So that's first.
But let me just say that, as Ms. Rapadas has pointed out, first of all, in terms of trying to bring the force majeure language of that is as a intervening and superseding defense that supposedly tracks the force majeure clause. Neither of those words appear in the text of the clause, and as pointed out, there are various doctrines in reference to force majeure and the intervening and superseding defense, which you were allowed to argue that these were just separate, seemingly separate language that is other than what is provided in in the lease agreement?
The way I would respond to that, Your Honor, is this affirmative defense for superseding and intervening causes beyond Mariana Stone's control is paragraph 9. It doesn't matter that paragraph 9 is called force majeure, because under the terms of the lease, that's not controlling. What's controlling is the substance. And the language that was asserted in the affirmative defense, to the extent we even needed to assert that as an affirmative defense, which we submit we didn't, tracked and gave fair notice, tracked the language of the extraction lease, and gave fair notice to Ms. Palmer of what Mariana Stone's position was. And in terms of timing, what I would submit is the context is not, it is not a matter of there were 2 years to wait to bring this up. The motion to amend deadline was 13 days after the scheduling order was issued. The scheduling order was issued in June 4th, 2013. The motion to amend deadline was June 21st, 2013. The first time the issue was raised by Ms. Palmer was November 2014. And the court issued its decision January 2015. It was after that that we filed the motion to amend, and there was no trial date pending because the case had been reassigned. So the motion to amend was filed within not 2 years, but within 10 months of the court's decision in order issuing the in limine motion. But 2 things happened. The judge who was assigned to the case was disqualified. A new judge was assigned and new counsel came in. Now, but what it comes down to on amendment, and again, I don't think we even needed to plead either one of these as affirmative defenses to be able to raise them at trial. But to the extent we needed to, Rule 15, to the extent it applied, is a liberal standard where leave should be freely given. To the extent Rule 16 applies, that's a good cause standard. And the good cause in this case is that Mariana Stones wanted to be able to present its case on the merits based upon the language of the contract and the underlying dispute between the parties. Fair notice was given to Ms. Palmer. There was highly exaggerated prejudice by Ms. Palmer in her arguments against amendment and in her in limine motion. Highly exaggerated. She had very fair notice of the defense of Mariana Stone's position. If I can refer the court to the discovery responses in the interrogatories, request for production, and the supplemental submissions, and in the admissions, Mariana Stones gave notice regarding its position about the denial of permits, the 20 citations, the seizures, the court appearances, the criminal liability exposure, Ms. Kafke's motion to clarify, the inability to haul, process, and sell aggregate, the federal government actions in preventing and prohibiting those things, and provided documents in support of all of these positions, approximately 300 documents, including the agreement documents, the admission documents, interrogatory documents, admission documents, permitting documents. All of these things were provided. This was no surprise to anybody. And really what this was effective gamesmanship on the part of a very good lawyer on behalf of Ms. Palmer. Everybody knew what the issues were because these things, once Fish and Wildlife stopped Mariana Stones from hauling, Ms. Palmer herself, her attorney, her sisters, and other landowners all joined the conversation. Everybody was surprised when we look at the declarations that were submitted and we look by the landowners, when we look at the motion for clarification that was submitted by Ms. Caffey, when we look at the letter from Ms. Palmer's lawyer, everybody was surprised.
Let me ask you, Mr. Perez, let me focus on the frustration of purpose defense that was raised and tried by the court. I mean, I think you both agree on the basic elements for frustration of purpose, looking at whether the basic purpose of the contract has been destroyed, whether the event is of a nature to have not been reasonably foreseeable, and if the value of the counter performance has been substantially or totally destroyed. The MSC was responsible for securing the government permits that were needed to work on the property. And so couldn't they have safeguarded against the possible denial by Fish and Wildlife of the permit to extract the aggregate or to transverse the easement?
You mean within the contract language, Your Honor?
Within the contract, within the lease, yes.
Yes, Your Honor, and the parties did that. The parties did that in paragraph 9, for example, where paragraph 9 said, if performance is prevented or delayed by reason of a regulation or inability to obtain permits, then the party is relieved of liability. That's paragraph 9. Whether it's called force majeure or otherwise,
Right.
The parties contemplated this eventuality and allocated risk and provided for what would happen in that event. And so it was addressed in that language.
Yeah, I recognize the paragraph 9 force majeure clause discusses the inability to obtain necessary permits, plus also the a separate provision for cause not reasonably within the control of the party whose compliance is prevented or delayed. I think the trial court was left with examining your affirmative defense 4, as Justice Carbolito pointed out, and that the operative words in the affirmative defense 4 talked about intervening causes or superseding causes. But these causes, first of all, aren't in that force majeure. The intervening or superseding causes, as Justice Carbolito said, aren't in the force majeure provision. And if those terms, intervening or superseding causes outside or beyond your control, if the trial court found that that risk was a foreseeable risk, and it seems to have been because you included that in the permitting language and in the force majeure language, doesn't that then suggest that those events aren't outside your control? The outside MSC's control, so that they actually could have done something about it. I mean, I know the force majeure looks to excuse the performance under the contract if the permits can't be obtained, but when you're talking about intervening cause or superseding cause, you generally are looking at causes that are not foreseeable at the time that the contract was executed. So the idea that the permitting had to be obtained doesn't seem like something that was not foreseeable at the time.
Well, Your Honor, it's not only intervening and superseding causes, but causes beyond Mariana Stone's or a party's control, which tracks the paragraph 9 language. But with respect to, was it foreseeable?
But for the affirmative defense 4 only is the intervening and superseding causes. And I think that's where the trial court kind of was left struggling with the fact that, well, that's what you pled. But now you're bringing up this new defense, or at least it said, you say you're not required to plead it of force majeure under the contract and mitigation of damages. And it was saying you were doing this essentially on the eve of trial before it granted the motion in limine excluding those defenses.
I think number one, when the court granted the in limine motion, it should have applying the policies of Rule 15 and 16, and just ensuring that the case is tried on the merits versus, on a technicality. The court should have given leave at that point to amend, if amendment was necessary, which I don't think it was. With respect to foreseeability, the parties contemplated in the event permits would not be, if there was an inability to obtain permits, that was covered in paragraph 9. In terms of foreseeability, though, when we look at even objectively at the facts, Ms. Palmer gave a series of representations, warranties, and covenants regarding Mariana Stone's ability to extract the aggregate from the property, and that it would not violate any rule, regulation, law, etc. Mariana Stone's relied upon that. There are a series of facts which shows that this was not foreseeable. If it was foreseeable, Ms. Palmer certainly did not disclose any knowledge she had regarding any problems that could happen under the lease.
But
And
Mr. Harris, let me just, if I may interject at this point. The argument is that the acts of the Fish and Wildlife in denying the permit, you argue, may have not been foreseeable. I mean, we have parties here, sophisticated parties to this agreement. MSC is in the business of, in this case, doing the extraction of corals. It was represented by two sophisticated businessmen, and in terms of the environment that they were operating and access to the property. And while they may have provided, there is a provision in the lease agreement in reference to the permitting. It would seem to me that similar to the cases, the zoning cases, the licensing, denial of licensing cases that were cited by counsel for the appellee, it would not be beyond a business due diligence practice that even if the parties, and there was no evidence that Ms. Palmer would know that if she was to enter into this lease agreement, that subsequently the easement would be denied, but that this is a possibility. This is a possibility that after purchasing a property that is zone industrial, that subsequently it may evolve, and the circumstances that then there is going, the zoning would be changed to residential. So a sophisticated businessman, it should not come as a surprise that if that an easement is provided for in federal property going across a protected property, that the enforcement of what was effective at the time may be changed subsequent to entering into the transaction. So it would seem to me that in trying to see who should bear the risks, that in the event a permit is denied, there should be some provision in the lease agreement that address that issue. And I think that was part of also the issue with the trial court. And so and that this goes to the issue of foreseeability. Your argument that it wasn't foreseeable that Fish and Wildlife, or even if that it wasn't foreseeable that the sign that was posted at the entrance gave actual notice to MSC that a permit, a special permit was required. It would seem to me that the circumstances and the nature of the parties would lend itself that they should have accounted for such a circumstance.
Your Honor, it doesn't say, that sign does not say permits are required. It says special regulations apply. What special regulations? If we're talking about the Code of Federal Regulations, there's 50 titles with sections and subparts. There's no indication of what applies. Is it environmental? Is it administrative? Is it, nobody knows. Ms. Palmer didn't know. And I disagree that these were sophisticated people. There's no evidence that these were sophisticated people. In fact, my clients were, this is, although it's operating on Guam, these were Korean individuals.
But let me just say, Mr. Perez, and I'll allow you to answer the question, is that we had businessmen who was proposing to enter into a lease agreement worth hundreds of thousands of dollars, if not millions of dollars. And if there was a sign that special regulation may apply, and before you come onto the Fish and Wildlife property, before you get to Ms. Palmer's lot, it would appear to me that it would not be unreasonable to inquire as to what that may mean. Maybe it didn't say that it's the Code of Federal Register, this section, so that the company representatives would then ask the company lawyer to check what these provisions are. But I think the circumstances revolving around the transaction in which we're seeking to determine what was foreseeable, that these are factors that are relevant in my mind.
I understand, Your Honor, and I'd like to just address some other factors, which include that this right-of-way was, first of all, the property was zoned commercial since 1987. Secondly, this right-of-way was used for commercial vehicles used for commercial purposes, traveled by commercial vehicles for years, predating the extraction lease. There was development on these private properties, including a resort. There were buildings, there were structures. Fish and Wildlife never stopped anybody before. Fish and Wildlife never required permits before. All of this was new, and it was a surprise to everyone, as the excerpts of record demonstrate. For Ms. Palmer, for her sisters, the lawyer, other property owners, Mariana Stones. Was this foreseeable? We submit it was not. Was this dealt with in terms of allocating risk in the contract? Yes, in paragraph 9. If permitting was required, and if it was unable to be obtained, that's addressed in paragraph 9. The sole purpose of this.
Yeah, let me ask one question. When you bring up paragraph 9 and the posture of the appeal in this case, there was a summary judgment motion filed for breach of contract that was granted by the trial court. And so if you would have asked for summary judgment, if you had opposed a summary judgment, shouldn't you have brought up at that time the issue of the force majeure clause to prevent the breach of the contract? And now that that's gone, that time has already passed in which to challenge the summary judgment motion.
The summary judgment motion plaintiff did not address the issue of force majeure in the summary judgment motion, and I understand the court is saying, shouldn't Mariana Stones have? And in retrospect, maybe that would have put Mariana Stones in a better position in terms of arguing its position on appeal. But fundamentally, what we have here is an extraction lease with a sole purpose stated in the extraction lease, recognized by the court in the motion for summary judgment decision in order. The sole purpose was the extraction, and that purpose was prevented and destroyed. And if that could not happen under the lease agreement, what are the responsibilities of the parties? Mariana Stones is not liable if it can't obtain permitting. It tried and it was denied. And if I've answered the court's question, I just wanted to go back to superseding an intervening cause beyond control and just say the trial court didn't really address that at trial. The trial court conflated that with the impossibility and practicability and frustration of purpose defenses, even though it was an entirely separate defense. And in doing so, deprived Mariana Stones of that defense and consideration of that defense.
Right.
Your Honor,
if
I think I'd like to reserve whatever time is left.
Before you do so, and I'll allow you to do that, I want to ask Justice Merriman if she has any questions for you without cutting into your time.
Thank you. I have a question about the mitigation of damages issue. You claim that that's part of the responsibility of Mrs. Palmer to have proven that she mitigated her damages at trial?
Yes, Your Honor.
Did the Mariana Stone have any obligation to notify the defendant that they expected her to do that? Or was that part of something she should have known to prove?
I think, Your Honor, prior to Ms. Palmer issuing a notice of default to Mariana Stones did not anticipate that Ms. Palmer was going to take the position that they were in breach, because everybody was trying to rectify this position that the federal government had taken against Mariana Stones and the property owners. So this was during, Fish Fish and Wildlife started its actions, I think it was in 2012. And 2013 is ultimately when Marianas Stone stopped hauling aggregate because of all of the actions the federal government had taken. And during this period of time, up to a period prior to the notice of default, I don't remember when that is, so I won't make a representation. I don't think Marianas Stones anticipated that it would need to do that. After the notice of default was issued, I don't believe Marianas Stones said, hey, you've got a duty to mitigate. So in answer to the court's question at that stage, I don't believe that happened. At least the record doesn't show that happened in our brief. I don't think, though, that Marianas Stones is required to do that. I think that under the law, it's incumbent upon a landlord, a commercial landlord specifically, as a matter of law, to mitigate damages without notice, and that it's triggered upon upon abandonment or breach. And so that would be my response, Your Honor.
Thank you.
Thank you.
That's my only question at this point.
Thank you, Justice Merriman. At this time, Ms. Rapadas, you are recognized.
Thank you, Chief Justice Carbolito, Justice Torres, and Justice Merriman. May it please the court. Before I go into my argument, I wanted to correct for the record. I might have misheard when the case was called, but I believe the clerk called it backwards. I am actually representing the appellee, Rosanna Palmer. Peter represents the appellant, Marianas Stones. So just to correct that for the record.
That's my mistake if it was mislabeled. I wrote
no problem. No problem, Your Honor. I just wanted to make sure we're all on the same page. May it please the court. Your Honors, I have not been practicing an extraordinary amount of time, but I have been practicing enough to be experienced in the posture of civil cases, civil litigation. And this is one of, I would say, my first cases which actually lived a full and complete life. It's one of those rare cases, I think in the 3% that went from a complaint to discovery to dispositive motions to a belated motion to a motion in limine, to a belated motion to amend, and then a bench trial wherein the trial court issued findings of fact and conclusions of law. And so this case has had a full life. It is a complete record of what happened from beginning to end. And unlike many of the other cases that I've been a part of, this case actually had multiple levels of review. You had Judge Pears initially, who looked at the motion for summary judgment and the motion in limine. And then you have a disqualification, a recusal by Judge Pears, which eventually led to Judge Lamarana taking on the case. And then looking at what Judge Pears had done in the motion in limine, motion for summary judgment, and then deciding a motion to amend, and then the findings of fact and conclusions of law. This case was a singular, simple breach of contract case, Your Honors. And in his argument, Mr. Pears talks about gamesmanship on the part of myself, of not myself personally, but of Mrs. Palmer's lawyers. And what you see in this record, which is full and complete and I think clear, is that if anyone engaged in gamesmanship, it was defendants and its attorneys. What they did through their litigation strategy and their tactics was turn this simple case into an almost 7-year case. And after every defeat at the trial level, they repeatedly threw different tactics at the wall, hoping, mainly without any factual or legal support, and hoping that something will stick. You have belated defenses that were raised after the court had already found in a decision on a summary judgment that the plaintiff had met the essential elements of her breach of contract claim. And then after the trial court already found that the defendant had waived those defenses in its decision on the motion in limine, you have the defendants then, when it got new counsel and when it went before a new judge, then arguing that it should be able to bring those affirmative defenses that had already been excluded by a prior judge. And in addition to those defenses, bring 7 counterclaims and 15 more defenses. In a footnote, and I think this is really important. It's not something that was talked about in Mr. Perez's argument, but in a footnote in its opening brief, and I will get to this later as well, without any evidentiary support, Marianas Stones argues that none of the 4 alternatives proposed, and these are the alternatives that were proposed by the federal government, none of the 4 alternatives proposed was ever deemed feasible or agreeable by any of the parties whose consent would have been required. Ultimately, none of the 4 alternatives nor any other alternative was approved by the federal government. And Your Honor, this is just, they don't cite anything in their brief to the record that actually supports this. And it's a material statement because it actually goes to an element of their affirmative defense's frustration of purpose and impracticability and impossibility, which they did not meet at trial, and the trial court found as such. Your Honor, the record is clear as to what happened below and when in the last 7 years. And based on the established standards of review, which pose an extremely high burden on Marianas Stones, we would ask that the trial court's amended judgment be affirmed. Now, just to get this out of the way, Your Honor, the appellants do not challenge the motion for summary judgment and the court's findings that Mrs. Palmer had met her essential elements. So I want to dispose of that right away. What's before the court.
Before you do so, Ms. Rapadas, and since your 5 minutes has expired, and in your role in seeing this case from the beginning to the end, you're going to have the opportunity to provide input in making new law in Guam in reference to the issues in this particular case. On that note, what I mean is, why shouldn't we overturn the trial court for what may be really invoking the wrong test? We have, as set out in the briefs, there's the restatement rule, restatement second, contract section 261, the 1981, and in this case, in which what the trial court followed, the people suffer test in reference to the frustration of purpose affirmative defense. And the reason why I bring this up is because it seems to me that the restatement rule is a lot simpler as we make ourselves through this case, frustration of purpose, the impracticability component of the affirmative defense in terms of impracticability or impossibility. It seems to me that the restatement rule, which really says that after a contract is made, a party's performance is made impracticable without his fault by the occurrence of an event, the non-occurrence of which was a basic assumption on which the contract was made, and his duty to render that performance is discharged, as what Mr. Perez is arguing, unless the language or circumstance indicate to the contrary. Instead of the people saw 3-part test, we look, as Justice Torres, to the basic purpose, then we look to whether it was foreseen or not foreseen, and then we look to the value of the counter performance. So why shouldn't we adopt the restatement second, section 261 test in trying to define or set out what the standards are for the frustration of purpose defense?
Your Honor, first of all, I recognize that the court can ask this question. This is a question of law, and so of course you have to know what review over this. However, these were not arguments that were raised below, so I want to say that first. The defendants never challenged the standard or the elements of the affirmative defense that the trial court had applied in the motion for summary judgment, and which eventually led to the trial court's findings of fact and conclusions of law. However, when we, just to go straight to your question, when we did a review of this defense, and these were the primary defenses that were at issue in the case once the court really cleared the runway of the other defenses. When we looked at other jurisdictions and the standards that they applied, the standard was exactly what the trial court applied. And again, defendant didn't raise below that this was the wrong standard. In fact, they argued within the confines of those elements. And so, I don't think that is, I don't think it's a proper argument that, perhaps the defendant, if they wanted to, latch onto at this point.
So let me say then that if the standard in terms of we're going to continue to follow California law, and we look to the people's soft test in reference to the frustration of purpose, and then we go to the first element in terms of what was the basic purpose of the lease. The trial court said that the basic purpose of the lease was entering into a landlord-tenant relationship. And Mr. Paris says, no, that's not the basic purpose of the lease. The basic purpose of the lease was for purposes of extracting aggregates, and he provides a litany of reasons to support that. So even then, if we were to start with that test, and the first element that the parties must agree to the basic purpose, why was it? How is the trial court correct in coming out the way it did? Every lease you have rental of payments and lease of property. If that's the case, then there would be no reason for that first element of basic purpose.
Well, Your Honor, again, when we looked at this affirmative defense and looked at the jurisdictions, because we recognized that Guam courts had not looked or addressed this issue. Most of the jurisdictions employ the standards and the elements that the trial court did here, and it makes sense. If you impose a lesser standard upon the defendants, basically you make entering into contracts a risky business. It's always a risky business, of course, right? But if you're imposing a lesser standard on the defendants, when it's their affirmative defense and it's their burden to prove these affirmative defenses, then I think you're putting parties at a disadvantage to be able to use these affirmative defenses to get out of their contractual obligations. And that's what was the heart of this case.
But it's not necessarily imposing a lower test or a lower standard. That we're evaluating what was the basic purpose of the contract. And the trial court said it was to have a landlord-tenant relationship and for the tenant to pay rent to the landlord. But that's true in every lease. And so really, is that the purpose of the contract, as Justice Carbolito said? It seems like this lease is replete with references to the purpose of the lease being the extraction of aggregate and the payment to the landlord for the extraction of the aggregate. And as opposed to just simply being a payment of rent was the purpose of the lease.
Well, Your Honor, if we just talk about the first element, the purpose element, and I think it's important that the appellate court, sitting in the appellate court as an appellate court, apply the right standards to the trial court's findings below. The burdens here, the standards here are very high. So let's just assume that the standard of law that the trial court applied was wrong. Well, the appellate court still has to look at the findings of fact in the light most favorable to the prevailing party and resolve any uncontroverted facts in favor of the prevailing party. What the trial court did below was it looked at the lease agreement and it examined the evidence that was presented before it, including the testimony of Mrs. Palmer. And the trial court said, well, the purpose was disputed. And again, this is the defendant's burden at trial, is to meet these elements and to prove its affirmative defenses. So even if you're talking about purpose, and then viewing it in light most favorable to the prevailing party, which is Mrs. Palmer, under the standard that Justice Carbolito is talking about, I believe that the trial court would have still been correct. That look at, even though the lease agreement said, well, this is the purpose, was to extract aggregate. Well, the other provisions of the contract were very clear. Mrs. Palmer would be leasing, would be giving up her rights in her property. And again, this was an exclusive right. She provided to Mariana Stones an exclusive right to this property and to perform these, the enumerated uses on of the property. And in exchange, in the addendum, it's clear that she wanted minimum monthly payments. There was a risk involved that was recognized by Mrs. Palmer, and that's clear in the evidence below, that there might be aggregate that was extracted that was not usable. And so she wanted guaranteed minimum monthly payments. And so if you look at just the lease itself, taking away the evidence that was presented at trial, it's clear that the lease provided that Mrs. Palmer would get paid, and that was the purpose, a minimum monthly payment. We recognize that there was a total amount at the end that the trial court, did not apply here, but the minimum monthly, I think, was clear that was her purpose, was to make sure that no matter what happened, she was going to get paid for her giving up an exclusive right to the property to Mariana Stones.
Let me raise, going beyond the basic purpose issue and the dispute that surrounds that, and part of the reason why, and you're right, it's a question of law in terms of what tests, since we have this case of first impression. And the focus in terms of the restatement second, and rightly so, as I think in terms of shown by the facts of this case, has to do with the intervening event, the foreseeability issue, and in this particular case, as in reference to the foreseeability issue, why should we consider the Fish and Wildlife's denial of the permit foreseeable when, as Mr. Perez points out, that there were commercial companies, at least that's was established in the record, have used the easement extensively in the past with no issues. And so in reference to trying to determine whether or not Fish and Wildlife denying the permit or even that a permit for purposes of coming on the property through this easement would be denied, that this was, as Mr. Perez argues, is really not foreseeable when you look at it from the standpoint in terms of the prior use of this easement.
Your Honor, what we would argue is that the standard that needs to be employed for foreseeability, it's objective, it's not subjective. And this is something that we argued pretty extensively below and in the trial court, in the appellate briefs. The standard is it objectively is it foreseeable based on an objective standard? And what that means, it's not what was foreseeable to Mrs. Palmer. It wasn't what was foreseeable to her sister or to the Arteros that had used the easement prior to. It's based on an objective standard. What would a reasonable person under these circumstances have foreseen? And although Mr. Perez has presented numerous facts to say, well, to demonstrate that it wasn't foreseeable, including the fact that it had been used, no permits had ever been denied, which actually that's not supported by the record. What he uses are declarations wherein these laypersons say, well, I've never seen them do this, or I've never seen them do that. That doesn't prove that it's never happened. In fact, they didn't have any evidence below from the federal government that in fact, those regulations had not been applied or no one had been stopped from using that easement. But just going back to the foreseeability, Your Honor, as you pointed out to Mr. Perez, there was a sign. And the sign, and while Mr. Perez says, well, it says special regulations apply, but what special regulations are we referring to? There's a lot of regulations that could possibly apply. Well, first of all, prior to the statement on that sign, which is which is visible and which the defendants had admitted they saw prior to entering the lease, it says entering entering National Wildlife Refuge. So a reasonable person, and as Your Honor pointed out, a sophisticated person in their position entering into a contract with a minimum of $800,000 and potentially millions of dollars. A reasonable person in that position would have seen the sign, and after seeing the sign, inquired, well, what are the special regulations that apply? Just because the Marianas Stones didn't know what special regulations does not apply doesn't mean that it's not foreseeable. I mean, basically you're saying, what Marianas Stones is saying, well, there are these potential regulations that apply, but I don't know if it's going to be, I don't know if it's actually going to be enforced, and I don't know what they are. I think the sign is what completely undermines their argument that it was not foreseeable. And then it begs the question, well, at what point do they have a duty to inquire? If you're entering into a contract, again, worth possibly millions of dollars, do you have a duty to inquire when you see a sign that says, well, special regulations apply? Now, I'm not sure if Your Honors have been up to Retidian or Aru now, but the easement, it's a narrow road. I mean, there's one way in and one way out, which we stipulated to. In order to get to the property, you have to get on this easement. You have to traverse the easement. So at what point does a duty to inquire fall upon the defendants? And at some point, they can't point the fingers at everyone else and say, well, these are the representations that were made, or this never happened, or that never happened. Well, when you're entering into a contract, it's incumbent upon that party to inquire when they see a sign, what are those regulations? So I think the sign itself is clear evidence that it was foreseeable. And again, going back to the standard, the clear error standard, this burden is extremely high for the defendant to meet. I mean, the appellate court has.
Let me just say though that while the reasonable person standard is part of the consideration and how we should determine foreseeability, but and the subjective knowledge of Ms. Palmer, I don't though agree is not completely irrelevant. As you argue, it may be completely irrelevant because if even the owner of the property doesn't know about these regulations, and wouldn't that suggest to a reasonable person that it may not be foreseeable in reference to whether or not this special permitting is required to travel on the property where it had been used numerous times in the past and it without any incident?
Well, Your Honor, and I recognize that Mrs. Palmer is a sophisticated party. She's quite smart, but she was leasing her property. That was what her obligation was to provide this lease. In the lease, she put the burden on, or the parties agreed to put the burden on obtaining any permits and to performing all these other obligations. That was on the defendant. So even if Mrs. Palmer didn't know, she's an individual. She is not in the business of removing, excavating, selling aggregate. I mean, the supervening event well, it's not exactly a supervening event. The regulation itself existed prior to the parties entering into the contract, but the Fish and Wildlife's denial of the permit, which prevented the Marianas Stones from traversing the easement with the aggregate, that's something, as you point out, a businessman, a sophisticated businessman should inquire into. And so perhaps sitting in their chair as they negotiated the lease, it might not have been foreseeable, but at some point when they when they passed the sign, they entered into our property, they saw the conditions of the road, they saw that they were entering a National Wildlife Refuge. At that point, it was foreseeable that special regulations would apply. What those regulations are.
Ms. Rapadas. You know, the basic theory of the appellant's case here is that while they had the obligation to obtain the permits under the lease, also under the lease, if there was an inability to obtain those permits, they would be excused from their performance under the lease. And so how was, when this lawsuit was brought, how was Ms. Palmer denied a fair opportunity to defend against the basic premise that we weren't able to get these permits that we wanted to get, and therefore our performance under the lease should have been excused? And so why was she denied a fair opportunity to defend against that specific claim of theirs, number one? And then number two, what additional evidence would Mrs. Palmer have brought forward to defend against the excused performance of Marianas Stone?
Your Honor, just to let me address your first question. How is she not able to defend if this provision was in the contract? Well, Your Honor, although Mrs. Palmer was, obviously a party to the contract, had read the contract, as the plaintiff trying to enforce the contract, it's her obligation, and I think this goes to the basic duties of each party when they're engaging in civil litigation or litigation in general. She, as a plaintiff, her goal is to prosecute this case. Now, of course, as a plaintiff, you're going to anticipate, at least try to anticipate, what defenses are brought. She read the contract, was aware of the provisions in the contract. But the problem was not so much that she wouldn't have been able to defend it. The point is really, which again, let's go back to the decisions of the trial court in the motion in limine and the motion to amend. Was this defense waived? Was it brought too late? Is there prejudice? Is there undue delay? Now, even if as a plaintiff you anticipate the defenses of the defendant, it is incumbent upon the defendant to bring those defenses and to provide notice to the plaintiff that those defenses are going to be employed in litigation. Mrs. Palmer provided the defendant every opportunity to spell out what those defenses were. So even if, as Mr.
Wasn't it obvious that the basic reason they were asking to be excused from performance was their inability to get the permits? I mean, what were the other reasons advanced for not wanting to perform under the terms of the contract?
Well, Your Honor, even if that was an obvious fact, whether the defendant was going to actually use any sort of defense surrounded by those facts is, a different question, a different story. Again, it's about the notice that the defendant provides to the plaintiff about what defenses they're going to employ. And we asked the defendant in discovery, well, what are your facts and information to support your defenses? What are you going to use to try to excuse your performance? And nothing in those discovery responses did they use the force majeure clause. And even if they didn't say force majeure, they surely didn't point to the provisions of the contract. They didn't track the exact language of the contract. And then, as Your Honor pointed out— But did they
say it was a result of our inability to get the permits?
They didn't, Your Honor. Well, they provided facts. Certainly they provided facts about their inability to get the permits. But Your Honor, these are defenses that as the defendant, they have the obligation to provide plaintiff notice of. And we asked them specifically what defenses they would employ and give us the facts and information, and they didn't. And then when we brought the motion for summary judgment, they never argued the force majeure clause. It wasn't, again, until a week before trial, 7 or 10 days prior to trial, where for the first time they said force majeure. So I think the court, at least for your question, Your Honor, about whether we would have been able to defend ourselves, it's about the defendant's actions. Did the trial court abuse its discretion in finding that defendant waived the affirmative defense of force majeure and the other affirmative defense of mitigation of damages by bringing it so late in the game, especially after discovery had already closed and a motion for summary judgment had been decided and we were a week before trial. So it's about waiver, it's about prejudice. And I think the question, the issue of prejudice then goes into your second question, Your Honor, of what additional evidence we would have needed for the force majeure. Your Honor, I want to go back to the trial, the standards of review and the trial court's decisions. The standard of review is, did the trial court abuse its discretion in finding that the defendant had waived the force majeure clause? That was in the motion to eliminate. With the motion to amend, did the trial court abuse its discretion when it found, when it denied the motion to amend? Now, in terms of waiver, I think the record is very clear, as I spelled out, what happened and how belated these affirmative defenses came. Now, going to prejudice, we were on the eve of trial, Your Honor, when that motion to eliminate was brought. So, and discovery had been closed. And again, the trial court had already said, we are proceeding on these very limited affirmative defenses, and then it listed it out. Force majeure was not one of them. And then when a new trial judge came on and new counsel came on, they said, well, guess what? You know what? We are going to not only try to bring those 2 affirmative defenses, which we've already been told we can't bring, we are going to bring 7 counterclaims against Mrs. Palmer, and we're going to assert 15 affirmative defenses, new affirmative defenses for the first time. This is how many years after the case had started, discovery had closed, motions for summary judgment had been already decided, trial briefs, stipulated of facts, exhibits had all been submitted. There would have been extreme prejudice, which we argued, extreme prejudice to Mrs. Palmer if Marianas Stones was allowed to reopen the case and start from day one. And case law is clear that prejudice could result either through new discovery, which we would have had to look at all the discovery and evaluate what additional discovery we needed, if additional costs would be incurred, if new motions for summary judgment had to be brought or supplemented. And so I think the record is clear, the trial court was correct, and defendants have not been able to show that the trial court abused its discretion in finding those affirmative defenses were waived, or that they should not have been able to bring those affirmative defenses. And Your Honor, if I may just really quickly, I want to address the defendant in their reply brief asked that certain portions of our supplemental record be stricken. I just want to argue 2 things with respect to that, Your Honor. Number one, it's procedurally improper. They do not follow the appellate rules with respect to asking for that relief. And number 2, the defendant is asking that this court look at what happened below, multiple decisions, multiple filings, a whole gamut of evidence. In order to do that, the appellate court has to look at what happened below. And that's it. All of the filings that we put in our supplemental record all go to issues that are part of this appeal. And so we would ask that that request be denied, that we be allowed to include all of those documents in our record. And lastly, we would ask that the trial court's amended judgment be affirmed. Thank you, Your Honor.
Let me just say on that point, Ms. Rapata, since you raised it in your arguments on the motion to strike the briefing excerpts from the supplemental excerpts of record. And although, you know, it maybe have been an unconventional way in which to raise that issue on the part of MSC's counsel, I would like to point out, and you have argued strenuously in terms of the narrow issues that are on appeal. And when you append all the memorandum of law in the Superior Court, although I understand the argument that it may be necessary in reference to context, that maybe the better practice would have been to follow the rules, in my mind, and just stick to the issues that are on appeal. And should there be a need for further information from the record, we quite readily can obtain that. And but in terms of narrowing the issues and what is relevant, and that maybe there should have been a closer scrutiny. And I would just leave it at that. So let me just
I know
ask.
that her time is up, but can I just ask one follow-up question? And it really is just a follow-up to the previous
Yes.
question I asked.
Go ahead.
Could you give me one example, Ms. Rapadas, of additional evidence that you would have submitted to the trial court that wasn't already before the trial court or had not been admitted concerning the performance of the parties under the lease?
Well, Your Honor, I want to go back to even before that of what evidence we may have submitted. As part of discovery, if these affirmative defenses were allowed to go to trial, we would have argued that potential discovery had to have been conducted. No depositions were taken of Marianas Stone's corporate representatives. Mrs. Palmer's deposition had not been taken. And at that point of trial, those representatives were no longer available. And so that's why there was no new corporate representative. So just to even go back in time, the prejudice that would have resulted is additional discovery. Now, in terms of additional evidence, to go to either force majeure or to go to affirmative defenses, we would have asked Marianas Stones, did you appeal the denial of the permit? That was not, although we state in the record, there's no evidence to demonstrate that the denial of the permit was appealed. I mean, that's certainly something that we would have wanted to ask, because perhaps that may have strengthened their force majeure argument. Not sure as we sit here today, because those aren't the facts of the record that's before the court today. But that's potentially additional evidence that we would have submitted. If I sit here today, I might be able to think of additional things, but I might leave it at that. All
right. And I'm going to ask, because I allowed Mr. Paris additional time without cutting into his allotted time, Justice Merriman, do you have any concluding questions you would like to ask Ms. Rapadas?
Yes, I'd like to raise the same issue I raised with Mr. Paris. With respect to the mitigation issue, do you seem to argue that that's an affirmative defense that has to be raised? But assuming it is part of your case to establish mitigation, did you feel that you failed in that area, or could you comment on whose responsibility at trial it is to bring that issue forward?
Sure, Your Honor. In our briefs, I want to first address the question of whether it's an affirmative defense, because I think our briefs are pretty clear that jurisdictions who recognize it as an affirmative defense, even though it's not explicitly enumerated in Rule 8C. So I would first argue that it's clear in the majority of jurisdictions that this does constitute an affirmative defense. And so therefore the burden is on the defendant to prove it at trial. Now, as to your second question, if it was part of Mrs. Palmer's case to prove mitigation of damages, again, that was not fully fleshed out below that, because it was not something that was raised until late in the game, very late in the game. But I want to say this, this is an exclusive lease. And, I think if we go down the road of saying, well, did she prove mitigation of damages? If it was on her to prove mitigation of damages, I think it really begs a whole number of questions. What does that mean when you're dealing with a lease that provides for exclusive rights to a party? If she tried, for example, to mitigate her damages by going to find another buyer or going to find another lessee, would she then be in breach of the contract by trying to do that? So I think if we're asking that question.
Didn't she give notice that there was a breach of contract? At that point, didn't her obligation arise to mitigate the damages?
Well, Your Honor, she did give notice that there was a breach, and what the contract says, the defendants are to then cure. That's what the provision says. And so we allowed the defendants an opportunity to cure that breach, which, obviously they didn't do. as we learned in this case. And so even if the duty is onto the lessor to mitigate the damages, which, that evidence never came at trial. If it did, perhaps, we may have submitted evidence that Mrs. Palmer did in fact take actions to mitigate her damages. But that wasn't something that was fully fleshed out in the record, and is not something that I think we can decide up on appeal because of the lack of record on it, and because the defendant, as we argue, has waived it.
So your position is, if it was her obligation, she didn't have to bring evidence forward because it was waived?
Well, no, Your Honor. Well, our argument is that it's an affirmative defense, and therefore it was incumbent upon the defendant. It was their burden to present the evidence to establish that affirmative defense, and they didn't do it.
Thank you.
Thank you, Your Honor.
Thank you, Ms. Rapadas. And so how much time does Mr. Perez have on rebuttal?
23 seconds was what he had, or 27 seconds, yeah.
Okay. All right, Mr. Perez, I will allow you to wrap up.
Thank you, Your Honor. Just some brief comments. Number one, I just want to clarify that Mariana Stones gave extensive information in discovery responses of its defenses as far back as 2013. If the court looks at the excerpts of record, all of those facts underlying their defenses were given in 2013. Secondly, I would just like to clarify that it's our position the standard of review on appeal is de novo, because we're dealing with review of conclusions of law and contract interpretation. Third, regarding the purpose of the lease, there was a sole purpose. This was recognized by the court in its decision and order, page 177. The purpose was extraction. The extraction lease, paragraph 2, says the sole purpose is extraction. With respect to foreseeability, I just wanted to clarify, the federal government never invoked the CFR on which it invoked against Mariana Stones before. Everybody was surprised by this. This is shown by the declarations and the evidence that we've submitted at trial and on appeal. And finally, Mariana Stones had the right to rely upon the representations, warranties, and covenants that Ms. Palmer made in the lease agreement and prior to the parties entering into the lease agreement, under which they understood that they would be able to extract and remove aggregate from the property for purposes of manufacturing concrete. Thank you, Your Honor.
Thank you, Mr. Perez, and thank you, Ms. Rapadas. Again, the court thanks you for participating in our first virtual oral arguments hearing, and it shows that we are fully capable of continuing to conduct the business of the court, even if we're not permitted to actually be present in the courtroom. We all look forward to the days when we are able to do that again. But in the meantime, you have shown the court and the bar that we are fully capable of continuing the business of the Supreme Court in resolving the cases before it. And we thank you for that. So with that, the court will take the matter under advisement and the court stands adjourned. I would like to say to my colleagues that we'll schedule a time in which we can then discuss this case in panel so that we can arrive at a decision. And so with that, we will now terminate this proceedings.
Thank you, counsel. Have a good weekend.
Thank you, Your Honors.